As you may all know, we're approaching the end of the grace period, which is the 30th of June, for all EU applications. This includes both derivative applications, Zambrano, Ibrahim, Texera, Chen. If you were here by the end of December, then clearly you will have to make your application by the end of June. However, we are aware that there are significant number of people in the UK who are not aware of this deadline or are aware but haven't got the necessary skills to lodge the application because it's mainly done online, apart from the Zambrano and the derivative right applications, which is done by paper. Even on that, since yesterday, well, since Wednesday, the Home Office have now said that all applications that is done on paper, which includes all the derivative riders, Zambrano, instead of calling them for the forms, you can now send a request by email, and then you can also make the application by email. So there has been a movement by the Home Office. But our main focus today is what happens if you miss the deadline, okay? Because that will happen. There are many, many people, significant number of people who will miss the deadline. Does it mean the end of the world? Does it mean that you have to be deported? Does it mean that you have to be removed? Does it mean that you have to stop working? Does it mean that you cannot longer rent accommodation? Does it mean that you will lose your driver's license? Because we all know that if you don't have residency, lawful residence in the UK, you will lose your right to work. You also lose your right to a UK driver's license and also the right to rent. So these are very, very important decisions that people have to make. But as I've said, the Home Office have now set out in their guidance notes, the latest one is dated the 21st of May, 2021, which clearly provides some avenue and recourse for people who may miss the deadline. The exemptions cover children, and this will be children under 18 and all children in care. So if somebody misses the deadline and the person is a child, then the Home Office have said that in all cases, they should take a flexible and a pragmatic approach to people that they encounter who do not have residency, have not made an application under the EU SS. So the focus is on the concept of approach. And they've said that they should be flexible and pragmatic. And the exemption, as I said, applies to children. So this will be children in care or caregivers. Caregiver is somebody who's been in care and have left care. Care is a public law or application under the Children Act. And all children who are living with parents and the parents themselves have not made that application and therefore the child is not applied. So if you fall within that category, you will be exempt. So you can make your application even after the 30th of June. The next category of people comes within the definition of physical and or mental, people with challenging physical or mental health issues. This it's not people who are, for want of a better word, in a mental health home, but we're talking of people with Alzheimer's disease, dementia, people who are living in care homes, people who have certain challenges. It may not be pronounced, but if you clearly have physical challenges and you cannot use a computer, the emphasis is on digital illiteracy. So if you're digitally illiterate, then of course you will have an exemption, which means that you can also make your application after the 30th of June. In fact, they said you can make your application after several years. After several years. So people who miss the deadline, if you have a genuine case and fall within the category of classes of persons who have been defined, then of course you can make your application after the deadline. Also, victims of modern slavery, that itself is a concept which the Home Office takes seriously, These are people who've been brought to the UK by other residents and have been kept at home, used as maids, servants, and all, for want of a better word, slaves. They are called victims of modern slavery. So if you fall within the definition of a victim of modern slavery, then again, quite clearly, you will fall within the class of exempt people who can make the applications after several months or after several years. Then the next class of people are people who are in domestic violence situations or from abusing and controlling environment. So usually will be women or men, children, and adults who may have been caught up in relationships where the other parties abuse them and or have experienced domestic violence. Again, if you fall within this class of persons or people, then clearly you will be exempt. And even if you don't make your application by the 30th of June, you can make your application after, several months after, or several years after. And then we have other compelling practical or compassionate reasons. Other compelling practical or compassionate reasons can be anything from lack of computer to lack of internet. So anything that falls within any situation that can be interpreted as a reasonable explanation for not making the application will cover you. For example, if somebody is recovering from COVID, it may be that you're no longer COVID positive, but you are recovering from COVID. You will be covered. You live in an area where there's no internet, you will be covered. You live in an area where there's internet, you haven't got money to get the internet, you will be covered. You are an illiterate person, you will be covered. You are not illiterate, but you have challenges, you will be covered. You didn't know. If you say, I didn't know that I had to do it, you will be covered. So all the fears that we had, it seems the Home Office have listened to us and they've amended the initial class of exempt persons were very limited. Adding the people with other compelling or compassionate circumstances covers a broad spectrum of persons, and it covers almost everyone who misses the deadline. It doesn't mean that you've been given a blank check to miss the deadline, or that you've been given a free way not to make your application, because they will have to assess every application with your reasons for not applying and decide whether you fall within exempt persons. Also, people who have residency under EEA regulation. So if somebody's got permanent residence, if somebody's got residence card 5 years under the old style, and they don't make the application by the 30th of June, these people are covered as well. You can make your application anytime, several months after or several years after. Again, you need to explain why you didn't know. And then also people who may have issues with documentation, maybe their passport is not available, they don't have evidence of relationship, or they don't have the EE nationals details and stuff like that, you will be captured. And finally, the Home Office have said that if you are encountered by an immigration and enforcement officer after the 30th of June, so from the 1st of July, the Home Office have said that if you are encountered, one, you should be given the chance to apply within 28 days, and you should also be served notice to apply. So when they encounter you, whether or not you qualify, that's not their concern. Their concern is that if you tell them that I'm here because of an EEA national, or I am an EEA national, they've been advised and instructed not to detain you, but serve you notice to make your application within 28 days. Finally, there are those who are concerned that if I come from outside after the deadline, can I make an application? The withdrawal agreement provides various scenarios where you are covered. So people who are living in the UK as at the 21st of April must make the application by the 30th of June. Any person who arrived in the UK after the 21st of April has 3 months to make the application. Can I repeat that again? If you are a resident in the UK, so you came with a family permit, or you were in Ghana, you came back to the UK, or you came before the 21st of April, you have 3 months to make your application. Sorry, your application must be made by June. But if you came after the 21st of April this year, then you have 3 months to make your application. And therefore, although the 3 months will exceed June, you are still within the category of people who are captured under the withdrawal agreement. Finally, the withdrawal agreement itself, if you look at Article 4 of the withdrawal agreement, if you look at paragraph 5 and paragraph 6 of Schedule 3 of the Immigration and then the Social Security Coordinating EU Withdrawal Agreement of 2020 and the Consequential Savings and the Transitory Provision, EU Exit Regulation 2020. It's a very long law that protects almost everyone who was resident in the UK by the 31st of December. So Article 10(1)(f), for example, will cover people who have retained their right of residence. If you look at a case of Monday, which is spelled Munday, which is a 2019 citation, it clearly says that in cases where the Home Office is being difficult, because you were here by the 31st of December, you will be protected by the withdrawal agreement under paragraph 5 and 6 of Schedule 3. So again, a broad spectrum of protection, but it will be a legal argument. And my parting words to you is please make your application before the 30th. However, if your application is not made by the 30th, the withdrawal agreement protects you, the Home Office guidance protects you, and also you may fall within a special category of persons who have been classified as exempt and may have a plausible and reasonable explanation why the application was not made by the 30th. Thank you very much.